The envelope was still sitting on the passenger seat of my car when my brother's wife posted the photo to Instagram. I saw it because my phone was charging in the cup holder and the screen lit up with the notification, and there she was, smiling under the string lights of a restaurant patio in Sausalito, a glass of Prosecco raised toward the camera. The caption reading finally, "Peace of mind" with 3 heart emojis and a champagne bottle. My brother was in the background, half-turned, laughing at something the waiter had said. They had ordered the tasting menu. I could tell because of the small plate of oysters my sister-in-law had photographed earlier that evening, which had appeared on her story about 90 minutes before this one, and the tasting menu at that particular restaurant was $340 a person, not including wine. I knew this because I had eaten there once, years ago with my mother for her 65th birthday, and she had folded the receipt into her wallet and kept it there until she died. I was parked outside the law office on Magnolia Avenue. I had just signed away my share of my mother's estate. The papers were in a manila envelope on the seat beside me, and my hands were still resting on the steering wheel because I had not yet decided whether to start the engine. The afternoon light was doing that thing it does in the East Bay in early October, going gold and slightly green at the edges, and I remember thinking that the air smelled like eucalyptus and gasoline, which is a very specific Berkeley smell, and that I had not eaten anything since 7 that morning. My phone buzzed again. This time, it was a call. A number I didn't recognize but with the same area code as my brother's attorney. I let it ring twice before I answered because something in me already knew. The voice on the other end was breathless in the way that people who are usually composed sound when they have lost their composure very recently. He said my name first, asked if I was still at the office. I told him I had just left. He asked, and I could hear him swallowing between the words whether I had signed. I told him I had. There was a pause on the line so long I thought the call had dropped. And then he said, very quietly, "I need you to come back. Right now. Please don't drive home." I asked him why. He said, "Your brother and his wife. I just got off a call with the trustee. There's a provision in your mother's original instrument that I don't think any of us read carefully enough. If you've signed under what could be construed as material misrepresentation, the whole thing collapses and not the way they think." I told him I would call him back in 20 minutes. Then I hung up, and I sat in the car, and I watched the sky turn the color of the inside of a peach, and I thought about everything that had happened in the past 14 months, and how I had gotten to the parking lot of a strip mall in Larkspur, holding an envelope I'd been told was the price of my freedom. It started in August of the year before, when my mother called me on a Wednesday afternoon to tell me she had been given 6 to 9 months, possibly 12 if the immunotherapy worked, which it didn't. She said it the way she said everything difficult, which was matter-of-factly, with a small laugh at the end, as though to apologize for the inconvenience. She was 68. She had been a high school librarian for 40 years. She lived in the same house in Albany, California that she and my father had bought in 1979, a small stucco bungalow with a lemon tree in the back and a Meyer rosemary that had grown into a shrub the size of a Volkswagen. My father had died of a heart attack in 2014. My brother lived in San Rafael with his wife and 2 children. I lived in a 1-bedroom apartment in Oakland, 20 minutes from my mother's house in good traffic, 45 in bad. I am a forensic auditor for a mid-size accounting firm in Emeryville. My specialty is what's called fraud examination support for civil litigation, which means I spend most of my professional life reconstructing financial timelines from incomplete documentation, looking at what people moved and when and why, and explaining it to attorneys in language they can present to a jury. I'm 31 years old. I have a CPA and a CFE and a master's in accounting from a school nobody outside my industry has heard of. None of this is glamorous. What it meant, practically in the autumn my mother got sick, was that I knew how to read a financial document the way other people know how to read a face. Within a month I had moved most of my work to remote. I drove to Albany every morning at 6:30, made my mother breakfast, gave her medications, set up her hospital bed in the living room because she could no longer manage the stairs, and worked from her kitchen table until I needed to drive her to whichever oncologist or palliative care meeting was on the schedule that afternoon. I learned the rhythm of her medications. I learned which pharmacies carried which compounded preparations. I learned that her insurance company would deny a claim 3 times on principle before they would pay it on the fourth appeal, and that the appeals had to be written in a very particular register, somewhere between bureaucratic and threatening. I won most of them. The ones I didn't, I paid for out of my own savings, and I kept the receipts. My brother, whose name is, well, I'll just call him my brother because that's how I think of him now, in the same flat way you describe a piece of furniture you no longer own, came by on Sundays, mostly. He brought a smoothie from the place near his house, which my mother could not drink because of the dietary restrictions her oncologist had specified, and which I would end up pouring down the sink after he left. His wife came perhaps 4 times in 14 months. Each visit lasted under an hour. She wore very nice shoes and asked our mother whether the house was hard to keep up with, which I learned later was the beginning of a longer conversation she was having with herself about its market value. My brother had a habit, when he came over, of opening the kitchen drawer where my mother kept the medical invoices and pulling out a handful at random and standing at the counter going through them with the expression of someone who has just been told the restaurant is out of the wine he wanted. He would say things like, "Are we sure we're not being overcharged for the home health aid? And Mom, this is a lot. Is the hospice covering any of this? And I just want to make sure nobody's taking advantage." He never offered to pay any of it. He never even offered to look more carefully at one of the bills he had pulled out. He would shuffle them and put them back, slightly out of order, and then he would leave, and I would put them back in chronological order. And the next Sunday it would happen again. I am telling you this not because it's unusual, but because it isn't. I have worked enough estate cases professionally to know that there are people who treat caregiving as a debt the caregiver has chosen to incur, and there are people who treat caregiving as a debt the family owes the caregiver. My brother was the first kind. I had hoped, for 14 months, that he might convert. My mother died on a Tuesday morning in late September. She died at home, which she had wanted, with the hospice nurse in the room and me holding her left hand. My brother arrived 40 minutes later. His wife arrived 3 hours after that. The memorial service was on the following Saturday, a small gathering at the Unitarian Church where my mother had been a member for 30 years, and the reception was at the house. I was the one who made the food, because grief makes me efficient, and because I needed something to do with my hands. The conversation began before the last guest had left. My sister-in-law cornered me in the kitchen while I was rinsing the casserole dishes. She had a folder. She set it on the counter between the sink and the lemon tarts, and she said, in the tone of voice she used for problems she had already decided how to solve, that she and my brother had been talking with their attorney and there was something we need to walk you through, sweetheart. Because we want to protect you. I dried my hands on a dish towel and asked her to elaborate. She opened the folder. Inside were what looked like printouts of public records. Tax assessments, what she described as outstanding lien filings against my mother's property, a summary of estate liabilities. The numbers were large. They were highlighted in yellow. There was a column on the right labeled Estimated Personal Exposure, Beneficiary, and another labeled Recommended Action, and the recommended action in every row was the same: Execute Waiver of Inheritance. My brother appeared in the doorway as she was talking. He had a glass of wine in his hand and the expression of a man trying very hard not to look pleased with himself. She said the house had been refinanced multiple times before our father's death and that there was a balloon payment coming due that my mother had been hiding from us. She said the IRS had been in correspondence with the estate for years and that there were back taxes owed on rental income my mother had supposedly underreported. She said that the executor, who was my mother's longtime estate attorney, a man named David, who had drafted my parents' original trust in 1996 and updated it twice, had been evasive with them about the scope of the liabilities. She said that if I accepted my share of the estate, I would inherit a proportional share of these debts, and that her estimate, and we've done the math, was that I would be on the hook for somewhere between $260,000 and $360,000 and $310,000 I did not have. She said that she and my brother had spoken with their own attorney, a man whose name I had never heard before, and that he had advised them, reluctantly, that the cleanest way to protect me was for me to execute a full waiver of my beneficiary interest, at which point my brother, as the remaining named beneficiary, would absorb the entire estate, including its debts, which their family was in a position to absorb, in ways that I, a single woman renting in Oakland, was not. My brother, from the doorway, said, "Sis, we don't want to do this, but we've looked at it from every angle." It was, I want to be clear, a beautifully constructed lie. It had the architecture of competent fraud. The figures were specific enough to be intimidating, vague enough not to be immediately verifiable. The framing, "we're trying to protect you," was emotional armor against any pushback. And the deadline they introduced, almost as an aside, was the kind of deadline that exists in fraud cases and almost nowhere else. Their attorney needed the waiver signed within 21 days, or the IRS would begin asset seizure proceedings against me personally. I did not respond that night. I told them I needed to grieve. I told them I would think about it. My sister-in-law squeezed my upper arm in the way she did when she was performing tenderness, and my brother kissed the top of my head, and they left. And I locked the front door and sat down on the floor of my mother's living room and looked at the dent in the carpet where the hospital bed had been. The next morning, I drove to my office in Emerville and I sat in my own conference room with the folder, and I opened a blank spreadsheet and I began to do what I do for a living. By 11 o'clock that morning, I had identified 4 discrepancies. By 2 in the afternoon, I had identified 14. By the end of that day, I had pulled the actual public records, the assessor's filings, the recorded deeds, the federal lien database, and I had a side-by-side comparison that showed, unambiguously, that the documents in my sister-in-law's folder had been fabricated. Not all of them. Some were real, but they were either irrelevant or they referenced periods that predated my mother's ownership of the property in question. The dollar figures had been invented. The IRS correspondence she had described didn't exist. There was no open inquiry against the estate, and my mother's last filed return, which I had helped her prepare 2 years earlier, was clean. I called David, my mother's estate attorney, the next day. I asked him 3 questions. The first was whether there were any open liabilities against the estate. He said no. The second was whether he had had any communication with my brother's attorney. He said yes. 1 phone call, in which my brother's attorney had asked him very pointed questions about the structure of the trust and the enforceability of beneficiary waivers, and that the call had ended when David had declined to discuss it further without me present. The third question was whether the original trust contained any provisions I should know about that might bear on what I was about to describe to him. There was a pause. Then he said, "Why don't you come into the office and I'll show you something your mother and I drafted in 2019. I drove to his office that afternoon. He was an older man, late 70s, the kind of attorney who keeps a humidor in his office and writes notes in the margins of his case files in fountain pen. He pulled the trust binder out of a drawer in his desk and turned to a tabbed section about 3/4 of the way through. The provision was titled In Terrarum an Anti-Corrosion Clause, and it read, in essence, that any named beneficiary who, in the determination of the trustee or a court of competent jurisdiction, attempted to obtain a waiver, disclaimer, or release from another beneficiary through fraud, duress, material misrepresentation, or coercion, would forfeit their own beneficiary interest in its entirety, with such forfeited interest passing instead to the remaining beneficiaries pro rata. David said, "Your mother insisted on this in 2019. She didn't tell me why. I assumed she had her reasons." He looked at me over the top of his reading glasses. Was she correct to have her reasons? I told him she had been. He asked me what I wanted to do. This is the part of the story where I have to be honest about something, which is that I had, for the entire 14 months of my mother's illness, been carrying a particular kind of anger that I had not allowed myself to look at directly. I'd been so focused on her care, on the appeals and the medications and the small dignities of keeping her comfortable, that I had not had the bandwidth to feel angry at the people who were not helping. Sitting in David's office, looking at the clause my mother had drafted with him 5 years before she got sick, 5 years before any of us knew what was coming, I felt that anger arrive in me as a single, very clean sensation. It was not rage. It was something colder and more useful than rage. It was the recognition that my mother had seen this coming. She had known her own children, and she had built a small, quiet legal structure to protect me from them, and she had never said a word about it to anyone, because she had hoped she would not need to. I told David I wanted to think about it overnight and that I would call him in the morning. I did not sleep that night. I made tea. I went for a walk at 3 in the morning around Lake Merritt, which is something you should not do alone in Oakland, but I needed the air. By dawn, I had a plan, and by 9 the next morning, I had purchased a small digital voice recorder at the electronics store on Broadway and tested it twice in my car. I called my sister-in-law that afternoon. I told her I was leaning toward signing, but that I had some questions and that I wanted to meet with both of them in person before I made a final decision. She suggested dinner at a wine bar in Larkspur near their attorney's office. I agreed. I drove up the next evening with the recorder in the inner pocket of my jacket and a notebook in my hand, and I sat across from them in a corner booth and I ordered a glass of sparkling water. I want to walk you through what they said because I think the specifics matter. My sister-in-law began by reiterating the financial picture in her folder. She added some details that were not in the original document. She said the estate had also received a notice of pending litigation from a contractor who had done work on the house in 2018, which was not true. And she said that my mother's reverse mortgage had a clawback provision that would activate upon transfer of the property, which was not true because there was no reverse mortgage. My brother, who had been mostly quiet, then volunteered that their attorney had told them I was at risk of personal civil liability if the IRS found I had constructive knowledge of the underreported income and that he was trying to keep me out of court. I asked as gently as I could, what would happen if I chose to retain my share and address the liabilities directly? My brother set his wine glass down. He did this slowly. Then he leaned across the table and he said, in a voice that was somehow quieter and more violent than any voice I had ever heard him use, that if I disrupted the arrangement they had worked very hard to put together, he would file suit against me personally for the full reimbursement of medical expenses he claimed his family had paid during our mother's illness. He named a figure. The figure was over $400,000. His family had paid nothing. He said that he would name me in a civil complaint, that he would ensure my employer was aware of the suit, that he would make it very, very difficult for me to continue practicing in the Bay Area accounting community, and that this would all go away if I simply did the thing we have asked you to do. My sister-in-law, at this point, reached across the table and put her hand on mine and said, in a voice loud enough for the recorder, "Sweetheart, we love you. We just need you to make the right choice." I let my eyes fill, because they did fill on their own, and I told them I understood, and I told them I would sign on Friday. They paid for my sparkling water. We hugged in the parking lot. My sister-in-law smelled like the same perfume my mother used to wear, which she had borrowed from my mother's bathroom at the memorial reception, and I had to wait until they had driven away before I let myself feel anything about it. Friday came. I drove to David's office in Larkspur. Yes, the same David, my mother's attorney, who had been retained by the estate and who had agreed to be present at the signing. My brother and his wife arrived 10 minutes later. Their attorney was on speakerphone from his office in Walnut Creek. The waiver document was on the table. There was a pen on it, laid diagonally across the signature line, the way a hotel concierge lays a keycard on a counter. I performed hesitation. I asked David in front of all of them whether signing this document would release me from the liabilities my brother's attorney had described. My brother's attorney answered for him. He confirmed on the record on speakerphone that executing this waiver fully indemnifies the disclaiming beneficiary against the financial exposures previously identified. My sister-in-law nodded vigorously. My brother nodded too. I asked one more question, which was whether there was any other structural element of the estate I should be aware of before signing. David, who is a beautiful actor when he needs to be, said with perfect blandness, "No, this is a clean waiver. Standard form." I picked up the pen. I signed every page. I initialed the addendums. I dated each signature. My sister-in-law was already on her phone before I had capped the pen. She was texting the restaurant in Sausalito to confirm their reservation. My brother shook David's hand. They left the office together, his arm around her waist, and she was laughing in a way I had not heard her laugh since before our mother got sick. What they did not know was that 20 minutes before the meeting, I had filed an emergency petition with the probate court, accompanied by the audio recording from the wine bar, a sworn affidavit from me, a sworn affidavit from David, copies of the fabricated documents from my sister-in-law's folder, and a side-by-side comparison of those documents against the public records they had supposedly cited. The petition requested a ruling that any waiver executed by me on or after the date of the wine bar meeting be deemed voidable on the basis of fraudulent inducement and coercive duress, and that the interim clause in the original trust be triggered as to my brother's beneficiary interest. The court accepted the petition for emergency review that afternoon. The phone call I received in the parking lot, the one from my brother's attorney, was him realizing what had happened. He had received notice from the court at the same moment my sister-in-law was posting her Pradesho photo. He was calling me, I realized later, not to threaten me, but to try to walk it back. He thought, briefly, that he could still unring the bell. By the time he called, he could not. I did not go back to the office. I drove home to Oakland. I made myself a piece of toast. I sat on my couch, and I watched the light come through the window, and I thought about my mother, and I thought about how strange it was that the most loving thing she had ever done for me was something she had done in a lawyer's office 5 years before her diagnosis, without telling me. On the chance that she might be right about her own children, I cried for about an hour. Then I made a second piece of toast. The court's ruling came down 11 weeks later. The waiver was set aside on the grounds of documented fraudulent inducement. The interim clause was triggered. My brother's entire beneficiary interest was forfeited under the terms of the trust itself, and that interest passed to me. The recording from the wine bar was admitted into the record. The fabricated documents were entered into evidence. My brother's attorney was referred to the State Bar of California for a disciplinary inquiry into his role in the preparation and presentation of the materials. The reverse mortgage that didn't exist, the IRS inquiry that didn't exist, the contractor lien that didn't exist, all of them appeared in the court's findings of fact as fabrications, and the language the court used was clinical and devastating. My brother filed an appeal. The appeal was denied within 4 months. He has not spoken to me since the ruling. His wife sent me one long email about a year ago, which I read once and then deleted, in which she described herself as a victim of her husband's pressure and asked whether we could find a way back to family. I did not respond. I have no plans to. I sold my mother's house the following spring. I did not want to live in it. I used part of the proceeds to pay off my student loans, which I had been carrying since graduate school, and I used another part to set up a small fund in my mother's name at the public library system where she had worked, for the purchase of large print books for elderly patrons. The remainder I invested. I moved out of the apartment in Oakland into a slightly larger one in Alameda with a view of the estuary. I adopted a tabby cat from a shelter in Hayward and named her after a character in a novel my mother had loved. I started seeing a therapist on Tuesday evenings. I learned, slowly, how to fall asleep without listening for a hospital bed. What I want to say, and I am trying to say it without making it sound neater than it is that I do not feel triumphant about any of this. I do not replay the wine bar conversation in my head with satisfaction. I do not enjoy the fact that my brother lost his inheritance. I would have rather had a brother who was not capable of what he did, and I do not think any court ruling will give me that brother, because that brother does not exist and probably never did. What I have instead is the knowledge that my mother knew him better than I did, and that she protected me from him in advance, and that the work I did for 14 months in her living room, the medications, the appeals, the small dignities, was witnessed by someone, even if that someone is no longer here to tell me she saw it. There is a version of this story where I did not buy the voice recorder. There is a version where I was too tired, where the grief made me pliant instead of careful, where I signed the waiver believing it was the only way out and never looked at the documents again. In that version, my brother and his wife are eating the tasting menu in Sausalito tonight, and I am paying off a debt that was never mine. I think about that version sometimes. I keep it visible the way you keep a near accident visible in your rearview mirror after you've already merged safely, because it reminds you what you almost missed. I want to ask you something, and I mean it sincerely. If the people you love most turned out to be the ones constructing the trap, if the threat and the comfort were coming from the same hand, how long do you think it would take you to see it? And once you saw it, what would you be willing to do with what you knew? I have thought about this a lot in the years since, and I want to say something honest about what I learned. because I think the story is easy to flatten into a tale about a smart sister outwitting a greedy brother, and that is not quite what it was. What I learned, first, is that fraud almost always wears the face of the person you trusted. Tobin and Sasha did not look like criminals when they came to me with that folder. They looked like family. They smelled like the perfume my mother used to wear. They squeezed my arm and called me sweetheart. The mechanism of every coercion I have ever audited professionally has been the same. The threat and the comfort coming from the same hand. And yet, when it happened to me in my own mother's kitchen, I almost missed it. I almost missed it because I was tired, and because I wanted to believe them, and because grief makes you want to be small for a little while. That is the cause, and the effect was a folder full of lies on my mother's counter 4 hours after we buried her. I do not blame myself for being tired. I blame myself slightly for almost trusting them past the point the numbers had already told me not to. That is the part I keep returning to. The second thing I learned is that the work I did for 14 months, the medication schedules, the appeals, the nights on the recliner next to her bed, was not wasted. Even though my brother behaved as though it had been the price of admission to a transaction. Caregiving is not a debt you incur. It is a thing you do because you decided who you wanted to be, and that decision belongs to you regardless of who notices. My mother noticed. She had noticed 5 years earlier when she sat in David Ashford's office and drafted a clause for a danger she could not yet name. The integrity I tried to bring to her last year was the same integrity she had brought to her last decade, and it met itself, eventually, on a piece of paper in the law office in Larkspur. The third thing, and this is the one I would want a younger version of myself to hear, when the people who should protect you turn out to be the ones constructing the threat, the right response is not louder grief or louder anger. It is quieter accuracy. Buy the recorder. Pull the public records. Find the older man with the fountain pen who has been waiting his whole career to be useful exactly this way. Move slowly, count twice, and let the documentation do what your voice cannot. Tobin lost his inheritance because he underestimated the auditor and his sister, and Sasha lost hers because she thought a folder was a weapon when it was only a confession. They wrote their own ending. I just filed it with the court.